Well, hello. We have a lot of areas to cover in this panel, all of them relating to the changing landscape in liability, new trends, new players, new risks, and new concerns. As you can see, we have a large and distinguished panel here today. Let me stop at the end. Tom Hill, he's Senior Executive and General Counsel for Environmental Health and Safety at General Electric. Sitting next to him is Richard Silbert. He's Vice President and Chief Litigation Counsel for Purdue Pharma. John Fund is sitting right there. He's an author and national affairs columnist for National Review. And sitting next to me is Michael Maddigan. He's a partner with Hogan Lovells in Los Angeles. Thank you all for joining us here today. So you all have different buckets of concern. Tom, I want to start with you. You're worried about the International Agency for Research on Cancer, part of the World Health Organization, something that's been around for a while. But why is this giving you worry and concern?
Well, one of the things that we have to deal with in litigation, and Elise has referred to the litigation machine, is the fact that you can get involved in high stakes litigation in a courtroom and the die's already been cast. And what we're seeing in trends are not just IARC, but organizations like our IARC, NGOs, policy groups, quasi-governmental bodies that will have a policy-driven approach to an issue. IARC, as an example, issues monographs on health, on cancer. They actually don't do assessments of true cancer risk. They talk about hazards. But in the world, once those are issued, they become the perception that X is a carcinogen. That then becomes reality. When you end up in a courtroom, you now have to deal with not only the actual evidence, but fight the public perception. It happens all the time in lots of health policy organizations. It's an area that, in order to address litigation risks, you got to get ahead of the curve.
Can you give us an example of where you've seen this play out?
Well, not for me personally, but a real popular example right now is IARC's decision on glyphosate for Monsanto. They've determined that it is I think it's a 2B, so it's some evidence of carcinogenicity in humans. Every single scientific publication that I'm aware of that's actually been peer-reviewed has come to the opposite conclusion. But yet, business will have to deal with that from a regulatory perspective overseas. It'll become an issue in litigation. I think for IARC, they've had one or two chemicals that they've determined are not some kind of carcinogenic risk. Health policies. They've
reversed themselves too, haven't they?
I think they have maybe once. Yeah. They've been forced to. But it creates an external debate that business has to deal with, and then that debate then flows right into the litigation arena.
Mike, you have a different issue. Yours relates to the hiring of contingency private attorneys by states and counties and localities. Talk to us about how that's manifesting itself, what effect it's having.
Sure. We heard talk earlier about the entrepreneurial nature of the plaintiff's bar, and one of the ways they're being entrepreneurial increasingly in recent years is by partnering with municipalities, counties, and other local entities in working on behalf of the public on a contingency fee basis. This has been a trend that existed for a while with attorneys general, and it's now spreading and sort of descending down the governmental chain. I think this creates some systemic problems that I like to put into three major buckets. The first is one that I think will be familiar, which is what I call the pylon phenomenon. That is where counties or cities bring actions against companies that really are in addition to or supplemental to actions brought by the main regulators of those companies, and frequently are really nothing other than, as the name I use suggests, a pylon. An example I like to use of this is, I'm from Los Angeles, as you heard, is the Toyota accelerator cases, which I think will be familiar to all of you. There was a multi-district litigation case pending in Orange County. Toyota was pursued by the Department of Justice and ultimately paid the largest fine ever assessed against an automaker. There also were numerous other suits by other attorney general. And amidst all this, the district attorney of Orange County filed the suit under California's unfair competition law against Toyota. And he was pretty open at the time, this was in the midst of California's budget crisis, that he said he did this because people in California, in Orange County, might be scared about their car, and he also was open about the fact that this was a good way for him to obtain funding through settlement of a number of his priorities that the county otherwise didn't have the resources for. So there are many other examples, but that's one example where it's not really, in my view, essential that he get involved. He had other reasons for doing it, and it leads to a pylon that over time can really make a big difference for companies who are facing crisis. The second problem with this is what I call the payback aspect. And again, there are lots of examples of this, but the fact is these contingency fee contracts are very lucrative potentially for the plaintiff's bar. They often are given out to political supporters of the officials who have the decision making, or have the power to make decision about what firms to hire. And sometimes, as again was the case originally with the Toyota contract, the county resisted disclosure of it on the grounds that it was privileged. And then the third thing I would say is a systemic problem with this, kind of apart from the intentions or ethics of the individuals involved, is what I call the squeeze aspect to it, which is simply that it's a reality that public officials have the ability to employ certain tools that private attorneys don't have. They can levy fines, civil penalties, some cases even treat things as misdemeanors, as is the case with some of California's unfair competition law. That gives the plaintiff's bar that's handling these cases on behalf of local governments tremendous tools and power that they wouldn't otherwise have to try to leverage into extracting a settlement. And so we're talking about unconventional drivers of liability, and I see this as a trend that is problematic on a number of levels and is somewhat unconventionally pushing increased liability.
Richard, Purdue Pharma manufactures OxyContin. You felt the effect of this, correct?
Absolutely. We have a common friend, Tony Rakakis, who has sued us along with 4 other manufacturers of opioids in what's been dubbed the opioid litigation. And what we have is we have City of Chicago, 2 counties in California, a county in Long Island in New York. And unlike the pylon, it's actually the opposite. FDA was brought this issue. Obviously, it's a critical public interest issue. What's going on with opioids in the United States? What's happening with this very important conflict between medicines, when used appropriately, have the possibility of alleviating pain. When misused or abused, can obviously result in overdose and death and addiction. It's a very critical public health issue. FDA, the expert agency, is grappling with it, and they've actually rejected efforts to restrict opioids. So make sure they're still available for patients in chronic pain. The plaintiffs aren't happy about that. And so rather than wait for the agency to give greater guidance, they've jumped on into this lawsuit. And one of the problems here is, as defendants, we worry about liability, we worry about litigation costs. Think about resolution. I was sitting at lunch with my friend General Baker, 159 counties in Georgia, 120 in Kentucky. If you're thinking of settling any one of these claims by paying money, how do you do that? I'm sure many times in this room, people have talked about how do you resolve AG matters. Do you have to multiply by 50 or 51 if you include the District of Columbia? What's the multiplier with a county or a city? It's enormous complexity and much greater difficulty in litigating and also trying to resolve these matters.
John, you've taken a look at something else which factors into the litigation landscape, which is the American Law Institute, a long-respected body who gives judges input on the state of the law. And your belief is that they've become more of an advocacy organization, is that correct?
Fair enough. By the way, just a 5-second side note. Early in my career, I actually worked for a year in Hollywood, and I know something about staging. I want to commend the ILR staff for
isn't it lovely?
The most impressive setting I've ever been in a panel.
I love the animation, how the wheels are turning as we talk. Very
A+.
sophisticated.
The American Law Institute is the most important legal organization non-lawyers have never heard of. It is 3,000 people, including all of the Supreme Court justices, dean of law schools, distinguished practitioners, and judges not only look at statutes, they look at case law, the precedents. The restatements of case law that the ALI does are relied upon like a Cliff Notes for judges. The Supreme Court refers to their restatements at least twice a month in their opinions. Very important. Well, a couple of years ago, the ALI decided we are going to redefine a little bit what we're doing. We're not just going to define what the law is, we're going to define what the law is or what a court might reasonably determine or look at the law and decide what it is, putting an element of subjectivity into it. For example, on battery. Battery has a legal definition. There's lots of case law. Last year, at their convention, the American Law Institute decided we're going to redefine it. Now, if you're extremely sensitive to any invasion of your space, something that might be completely unreasonable, and the person who's touching you or brushing against you might know that, that could be called battery. In other words, if I do this, maybe that's battery. I think if you're an employer, this has real meaning. And that's the kind of thing that's happening. Justice Scalia, before he died, warned that these restatements were becoming less and less useful to judges and more subjective, and said, I don't think we should give them any weight anymore. That was one of the last opinions that he wrote.
And are other judges paying heed to what he wrote or not?
It's a big debate because the American Law Institute is extremely distinguished. It's 97 years old. It has a wonderful pedigree. They still do a lot of good work. But I think there's been a silent coup among the staff and some of the people who spend all the time in the committees, and the most important people, of course, have other things to do. And they're slowly but surely redefining the law and having subjectivity enter into it.
But it's an iterative process, right? It goes back and forth before a final product is produced.
And it's ultimately voted on by the convention. But if you have taken things through the process all the way up to the convention, it is very rare for the convention to go against all of the committee and the staff recommendations and all of that. I'm not saying this is happening overnight, but we need to pay attention to it because their restatements are very important in contract law, product liability law, tort law, penal code, you name it. They eventually cover the entire legal process.
They recently rejected the affirmative consent standard in defining sexual assault. Is that an indication that there's a little bit of pushback here?
Oh, there was some very close votes at their last convention. There is a lot of pushback. 120 distinguished law professors have wrote a letter on that issue saying this goes way beyond what the law indicates. There is pushback. I think people in this room and people who care about the law need to get more involved, because if you don't get involved, the activists are going to hold more and more sway. And right now it's a close call. I'd say it's 50-50 as to whether or not some of the restatements are going to go in a different direction that the late Justice Scalia warned about. If people don't get involved, you're not going to like the outcome.
Mike and Richard, I want to loop back to your issue of contingency lawyers being hired here. It's a win-win for the localities and the cities to strike these deals with contingency lawyers, right? They have the potential to make some money. They develop some political profile, potentially. It's a big plus, isn't it? How do you counter it?
Want me to take it?
Sure.
I think that is often the way it's portrayed. I mean, some elected officials make arguments along the lines you're suggesting, basically saying, look, I mean, this is a no-brainer. I'm getting something for nothing. I can make some money for the county.
They get
we can
the
do some public
expertise
good.
of outside counsel.
Right. Incidentally, I can do something high profile for my own political career.
Maybe in the form of a donation.
Yeah.
Or at least in profile.
But I think there are two problems with it. One I'll call sort of an immediate problem, and one a more philosophical problem. The more immediate problem is just in most cases, it's really not fair. It's manipulative. You're not doing any real good for the public because you're often, as I said, piling onto something where action's not needed. And it's not really, I would argue, an effective use of your prosecutorial or legal power as a public official. More broadly, I think it leads to philosophical confusion that concerns me, and that is that I have a lot of friends in the plaintiff's bar, and those who articulate a philosophical kind of approach to what they do will say something like, "Look, you have three choices. You can have a very heavily regulated society where the government is who polices everything in detail. We don't want that. You can have a society where there's no check on powerful institutions and companies. We don't want that." So they kind of say it's a free market approach where we have this approach where we have private actors who for profit go out and try to do some policing through the form of these lawsuits. And yes, it's very inefficient, and yes, I make money on it, but it's sort of a la Winston Churchill, the best of all worlds, and the best of all worst worlds. That's the philosophical justification that you hear. And without debating whether that's right, the problem with having public officials and contingency lawyers partner, in my view, is that it really muddles that up, because the whole justification for contingency fees, if you look at it historically, is to give access to the courts to people who did not have it. And that is obviously not the case with government officials who own, maintain, fund the courts. And so this blurring of what it means to have the private actor and the public power is, I think, troubling for the long term. And actually, I think ultimately, although we'll see how it plays out, undermines some of the justification that the contingency fee bar has to itself about what it's doing.
Richard, would you go so far as to say it's changing the priorities of some of the local prosecutors or attorneys general?
I just think it makes it much easier for them to try and achieve what they want to achieve. I'll use another example with my California cases. Several years ago, we settled with the state of California, with the people of California, when they were represented by the Attorney General. So a few years later, we get sued by 2 counties in California under the same UCLA and FAL statutes on behalf of the same client, the people of California. I thought we had to deal with the people of California. But here's a local county politician who I think doesn't want to bring the action. They haven't said this. I don't think they want to bring the action on behalf of themselves, because then they're in federal court. But they bring it on behalf of the people, and they're stay in state court. But we already have a deal with them, and so. How many times do we have to litigate the same issue on behalf of the same client with different counsel?
Depending how deep your pockets are, that's the answer.
Maybe so.
Yeah, no, I've had that too. There's a comic aspect to it, and even some people have joked about it. I'm the people. No, I'm the people. No, I'm the people.
So it means more suits. And what does it do to the prospects for settlement of suits?
Well, it stinks. For the reasons I said earlier.
You get no closure.
You get no closure. How do you do this? As I said before, it's one thing to consider settling with a multi-state of attorneys general. What's the multi-county equivalent to that? And then you throw in cities. I'm going to settle with Philadelphia. Am I settling with Boston? Am I settling with Chicago? How do we do this as defendants?
So John has suggested an activist approach, that everybody become aware of what's happening and have their voices heard. Tom, what's your recommendation for this whole basket of issues, if you want to tackle that one?
Okay. Actually, listening to a lot of the panels, Brackett mentioned earlier that he has no problem, and I think none of us have any problem with the state of civil litigation when it's a plaintiff and a defendant. The evidence comes into a courtroom and you deal with it with respect to that case. Governor Romney talked about the role of general counsels in the boardroom, that they have to be able to have a bigger perspective, have data, look at trends. John talked about getting involved in the ALI process. I think the real challenge for us who are dealing in litigation reform and litigation risks is trying to figure out what these problems are going to be before they become so insurmountable that we can't deal with them. By the time the state's attorney general decides to bring a piece of litigation driven by an outside influence that isn't really related to a claim, but is more a policy-driven agenda, it's too late. One of the things that we struggle with and we're trying to do is figure out how to look at, as Governor Romney said, the data, the perspective, the trends, to see where risks are going to emerge. Are they going to be at the ALI? Are they going to be in science? Are they going to be at regulatory agencies who are not using sound policy or sound science to establish policy? That's a lot of work for us. It's a lot of work for lawyers, but it's something I think we need to sit back and spend more time and more money and more effort to try and get ahead of the curve.
Is anybody doing that?
Well, I'd like to think we're trying. It's a struggle because of all of the information that's out there. I mean, it's one thing that we can sit back and we can try and assume what the trends are. IARC, the example that I gave you, everybody knows about. The ALI is bubbling up, but it would have been nice to figure that out earlier. What we're trying to do is sit back and see whether or not we can use big data, whether we can use the internet to help basically scour information from a legal perspective, synthesize it down, and determine risks, and then get involved earlier. It's difficult to do, but it's something that we're trying to do at the beginning.
I'm going to put this on a personal level from people I've talked with. I cover healthcare a little bit. I've talked to doctors who tell me it was a great career to go into, but I would not recommend it to my children or my grandchildren because of all of the changes. For example, the American Medical Association was taken over by activists who basically fought for all kinds of changes that reduced the autonomy of doctors and created paperwork and bureaucracy. I do not want to happen to the legal profession what happened to the medical profession, where lawyers in this audience in a few years decide, I have had a great career, I've done good work, but I can't recommend this career to my children or my grandchildren anymore. That would be awful because the law is so vital to our country, the rule of law. If we lose the best people, Gresham's law of laws takes over. Good lawyers leaving, bad lawyers coming in.
And so do you think it's possible to get ahead of the curve and see what's coming down the pike, making it a less attractive profession?
I will just agree with Mr. Wood that the other side is relentless and they are spending an enormous amount of resources and energy on this. If you don't at least match them, you're not going to be happy and you eventually give ground. Maybe not this year, maybe not next year, but over the course of time, it's like the proverbial frog in the boiling pot of water. By the time you notice the water is boiling, it's too late.
I wanted to ask Tom a question.
Sure.
You talked about where the plaintiff's suits are getting ahead of the science, where the experts and the agencies are working on it or have different conclusions. In our particular case, we've made motions under primary jurisdiction to have the case stayed pending resolution of active investigations at the expert agency, in this case, the FDA. Mm-hmm. Judge in Chicago rejected it. Judge in California granted it, saying, I don't shrink from my responsibilities, but I shouldn't be deciding who gets what medicines for what purposes. That's not for me, or at least the underlying scientific issues behind that. Have you had any luck with making primary jurisdiction arguments or arguments under Landis to defer to the court should exercise its inherent jurisdiction over its docket?
Rarely, which is why we're trying to attack it from a slightly different path. I go back to that once you're in the courtroom, judges are going to deal with what they believe the facts are. And when they see information from a regulatory agency, for example, I do a lot of environmental litigation, judges recognize that when the Environmental Protection Agency says certain things about hazardous waste, it doesn't necessarily mean that it's hazardous or not. It's based on their regulatory definition. But when they have a perception that some other non-regulatory agency has come to some conclusions, they may actually give them far more credence. IARC is an example. And so what we're trying to do is help sway those perceptions and influence them before they become too big. I think the jurisdictional aspects, when you're in civil litigation, we're kind of left with the playing field we have. What we're trying to do is figure out a way, at least from a commercial perspective in the businesses that we're involved in, making sure that we understand what people perceive to be risks versus actual risks and help inform the community ahead of time. In the long run, to John's point, it is a lot of effort. It seems like it's an inchoate outcome, but the benefits will outweigh having to litigate in a playing field that's already been set. And I think that's just that's a sea change in the way lawyers need to think given big data.
Mike, do you think it'll fly?
I agree with what's been said. I mean, I think it echoes what Governor Romney said and echoes, the work of the Institute as well. I mean, you can't, as lawyers, just think of your task. I think now we can't think of it as being sort of a narrow, almost technical type of approach. When you're in court, you do this, or if you're faced with a regulatory issue, you do that. I mean, it's a broader type of effort that requires trying to see around corners, trying to shape opinion a little bit, trying to help clients do that, and trying to see what's coming a lot more.
We all know that we've done, a lot of us have done public policy work before. You can get regulatory changes, but they can go away, which is why you got to, I mean, it's a constant battle. John,
I understand the need for short-term thinking, let's say in corporations. You have to, working to the next quarterly performance. CEOs are geared to that. But companies do think in the long term. For example, lots of companies have a brand they protect. Coca-Cola, Bayer, OxyContin, they protect the brand. A lot of that involves long-term strategic thinking. We're not going to do anything that damages the brand. If we don't take seriously these threats to existing legal precedents and to existing legal norms, we're going to damage the long-term brand, and that'll hurt every place we work.
It also takes money to do it, doesn't it?
Well, companies will pay money to defend their brand.
Would all of your firms be happy to jump in? And
it's kind of the you can pay now or pay later Fram commercial. The conversation that we had just now about MDLs. I mean, and I agree wholeheartedly, it becomes a black hole of resolution. Avoiding one of those by spending some money up front is well worth not having to drop hundreds of millions of dollars in resolution for claims that don't really exist but are perceived to exist. So it's explaining that risk-benefit cost analysis is difficult internally, but I think it needs to be done.
Richard, you buying it?
Sure.
But I have to ask you, if you're
Talk to me afterwards.
if you're doing this analysis, the data crunching to figure out what's bubbling up, you said some of the things we're talking about have already been on the table. What are you seeing emerging? Can you tell us?
Sure. One of the things that on the environmental side, you see non-governmental agencies try and fix regulatory problems through the regulatory process, and they can't. I'll give you an example that people can appreciate going back in time. Fracking. The perceived risks of fracking are significantly different than the real risks. Regulators have a belief in what the risks are from fracking, water injection, earthquakes, that sort of thing, and they legislate, and they don't actually fix the right problem, but then we have to deal with that legislation. From a litigation perspective, there are claims that have no basis in science, but have a perception that in the community that they're true. We actually have been able to get a little bit ahead of the curve on that when we look at our oil and gas business, the kinds of things that we're going to be involved in and the things that we're going to stay away from.
And we have to leave it there. Thomas Hill, thanks so much for your input. Richard Silbert, thank you. John Fund. And also Michael Maddigan. Thanks all.